get started. Hi everyone, thank you all for being with us. This panel will discuss the future of privacy and data protection enforcement in the EU. And with me are, at the end of the table, Mr. Romain Robert. He is handling EDPB matters at the EDPS, and he was formerly at the Belgian Data Protection Authority. Next to him is Mr. Gwendal. He's Director of Technology and Innovation at the CNIL, and he also participates in Article 29 Working Party. Next to him is Ms. Karolina Mojzesowicz. She is Deputy Head of Unit on Data Protection at DG Justice at the European Commission. And next to her is Ms. Sachiko Scheuing. She's a European Privacy Officer for Acxiom, and she is also co-chair of FEDMA. And next to me here is Louveaux. She's Senior Managing Counsel at Mastercard, where she is responsible for privacy in Europe, Asia Pacific, Africa, Middle East, Central and Latin America. And me, I'm off counsel at WSGR law firm, specialized in EU data protection law. So this panel will discuss the future of privacy and data protection enforcement in the EU. And as you all know, the GDPR provides for a whole new data protection enforcement regime with new sanctions, notably high administrative fines, but also new rules on how to determine which DPA is competent to enforce, a new body, the EDPB, that will have to ensure consistent application of the GDPR. And so this raises some questions. How will these rules be applied in practice? What does this mean for businesses also? How can businesses prepare themselves? And I think our panelists will have very useful insights on this topic that can maybe help us answer some of these questions. So I will first give the floor to the chair of our panel, Mr. Gwendal, who can hopefully give us some of his views on the topic.
Yes, thank you. Thank you, Laura. Hello, everyone. I'll make 2 points maybe in the introduction. First of all, explaining that DPAs have been working together for many years already on enforcement. So the GDPR is organizing the enforcement procedures. And the second point is that we're trying to provide legal certainty upfront as much as possible on the enforcement cases. So these are the 2 points I'm going to develop a bit in my presentation. On the fact that we've been cooperating together on enforcement cases, if you look back 6, 7, a bit more years ago, we started to set up on specific enforcement cases on big internet companies, task forces at the Article 29 level to get a common understanding of a specific enforcement case. If you look back, there was the Google task force when we looked on the privacy policy, for instance, where people, all DPAs, all interested DPAs worked together to try to get a common understanding of what the issues were and what the conclusions or the compliance actions that had to be conducted were. And this was taken up afterwards, of course, at the national level, because in the current legal framework, the Article 29 Working Party does not give fines to companies or cannot send enforcement notices to companies. So what was done afterwards is that there was groups of DPAs that were involved in the enforcement cases, and they're talking together to try to reach a common understanding at the national level to make sure that the decision you take in member state 1 is consistent and is not contradicting the decision you're making in member state 2, which is, of course, sounds obvious because we have a common legal framework, which is the directive. And the directive is minimal harmonization of the member state law. So, of course, the member state law is derived from the directive, so you can have slight differences in the final decisions that are made by the DPAs on enforcement cases, but at the end of the day, the principles remain the same, and we were ensuring consistency through these task forces. The difficult time that we're having now with the existing legal framework on the directive is that, well, it's a directive, so you have different member state laws. So this means that when we had to coordinate our work among different DPAs, you have to deal with different member state laws, which have different procedures in them, and different powers for DPAs. So sometimes it makes it very difficult in practice to have a coordinated communication or making some coordinated progress in the procedures, because member state law imposes differences in the processes at the local, at the national level. Of course, this is going to be resolved with the GDPR, because the GDPR is organizing cooperation in a binding way. The principle we have in the GDPR, and I know Romain will speak a bit more about this, is whenever there is a case which is a transborder case, there's the interested DPAs, if you want, they get together. The lead DPA is going to propose a decision. The rule is the consensus, and if there's no consensus, there's a way to make some proposals to amend the decision of the lead DPA, and if after this process there's still no consensus, it goes up to the EDPB, which will take a binding decision that will be imposed on the lead DPA. But I know other speakers will be talking more about this. So what the GDPR is really doing in terms of enforcement process for DPAs is that it's organizing cooperation, and it's ensuring consistency of decisions by data protection authorities. But once again, it's not completely new, because DPAs have been working together for many years, and there's, if you look around a little bit in the public, in the press, there's a lot of cases where there's DPAs working together on specific cases, especially concerning big internet companies. One of the challenges, however, for us is going to be to meet the deadlines, because of course the deadlines in the GDPR are very tight when we have to make decisions jointly. And with respect to this, EDPS and the authorities at the national level are working on an IT system to exchange information in an efficient and effective way, so that it will support the decision-making process at the EDPB level. So that's very briefly the introduction for the first point, and I know my colleagues here on the panel will be speaking more about this. My second point is that if you want this enforcement process to be efficient, it's important that you provide as much certainty as possible up front. Okay, how do you provide the certainty? Not only ex post and say, well, it's a case, I haven't thought about this case, I don't know how to make a decision. Well, what we do right now is we work on guidelines at the Article 29 level to reach a common understanding of how the rules in the GDPR need to be implemented. And I think this is essential. It gives certainty on the DPA side, but it gives certainty on the data controllers side, because they know how we read, how we interpret the GDPR today. Examples of important guidelines, well, if you go to the Article 29 website, you will find all the guidelines that we've been working through. The process is an open process with a lot of consultation with the different stakeholders, because each time we've been working on a guideline, there was a public event, which was a Fab Lab, to gather some input from the stakeholders. Then we did our homework. We proposed a guideline that was published on the website of the Article 29, and this guideline was open to a public consultation for a period of 6 weeks, after which we analyzed the results of the public consultation, and we published the final version of the guidelines, which hopefully answers all the questions that were not already completely clear in the first version of the guidelines. So that's for the process. And for the guidelines themselves, I think I will just talk very, very briefly about 2 examples. One of them is DPIA. We did guidelines on DPIA, on what needs to be in the DPIA, when you need to do a DPIA, what needs to be included in the DPIA. At the French level, at the CNIL, we've built also a tool that is consistent, of course, with the guidelines and that helps you to do the DPIA. And these guidelines are going to be used in our decision-making process because, you know, for DPIA, authorities need to adopt lists for which DPIAs are going to be compulsory, and they may adopt lists for which DPIA are not necessary. So, in a way, the guidelines, in this context, they provide the framework to adopt the decisions at the national level, which in some cases need to go through the consistency to make sure that this is consistent throughout the EU. The second thing, maybe the other guideline is still in an ongoing process, is the guideline on data breach notification. The public consultation is now over. We'll have a final version of the guideline that is discussed at the next plenary of the Article 29. And of course, you explain how this new provision of the GDPR has to be implemented. And since it's a new provision which says that, very briefly, you need to have a register of the data breaches. In some cases, you need to notify to the DPA, which is going to be the lead DPA, and it coordinates with the other DPAs to make sure we have a common understanding of the measures taken to address the breach. And in some cases, you need to also notify the data subjects themselves. Well, it's essential that we have a common understanding so that when we make decisions, they're either only national or that need to go through the cooperation process at the EDPB level. We do this in a consistent way throughout Europe. So, and of course, in the enforcement, when we do inspections, it's likely that DPAs will check whether or not registers of data breaches have actually been implemented, for instance. So these guidelines, they provide the certainty, and they're the necessary tool for businesses to understand how it's going to be implemented, and they provide consistency ex ante on the inspections that will be conducted by the DPAs, which in the end lead to the enforcement processes. So these are the points I wanted to make in the introduction, and I think they will be addressed in more detail by some of the speakers afterwards. Thank you.
Thank you, Gwendal. And I guess it's a good tip for everyone to read those guidelines very carefully. Ms. Mojzesowicz, maybe you could give us the views of the Commission on the topic.
Perfect. Thank you very much. Good afternoon, almost, everybody. So, for us, from the substantial point of view, the GDPR, in comparison to the now applicable sorry, I was on the ePrivacy panel yesterday, so I'm changing the chip. So, GDPR, in comparison to the Privacy Directive, the Directive 95, is actually an evolution and not a revolution. Where we see a very important change, it's precisely in the way in which the GDPR rules are supposed to be enforced. Now, from our point of view, this maturity of data protection rules and data protection world within the EU is expressed precisely in a way that the GDPR equips data protection authorities with harmonized powers. Now, in Article 58, you will see a full array of powers which the GDPR gives data protection authorities, including the power to impose fines. From our point of view, from the point of view of the legislator, it was a very important element, this, first of all, harmonizing this power, and secondarily, giving really very tenable ways of enforcing data protection rules. Now, another element which Gwendal already mentioned is this element of cooperation, which already existed, but the GDPR provides for clear set of rules on the basis of which this cooperation can happen. Let me start with mutual assistance. Now, data protection authorities cooperate with each other, they help each other, but in the future, there will be, in the case of request of mutual assistance, actually only 2 points were requested, or the data protection authority to which another data protection authority is turning to, there will be only 2 points where such a request can be not complied with. Namely, when another data protection authority is not competent, or if such a request, or complying with such a request from another data protection authority would mean a breach, would infringe the regulation or the national law. So there is a very strong push towards the cooperation. Data protection authorities gain also the possibility to do joint operations. This is also a novelty in comparison to the Directive 95. Now, having said that, these tools of cooperations, I would like to tackle and to develop a little bit more this way of finding one interpretation of the regulation in all cross-border cases. So the cooperation mechanism on the basis of Article 60. In all cross-border cases, within the decision of how the regulation should be interpreted, the data protection authorities are incentivized to find a consensus, and if it is not possible, there is a possibility to go to the European Data Protection Board, which will adopt a binding decision giving the interpretation of the question which will be then raised in relevant and reasoned objection, which this binding decision will be addressed to the concerned authorities. It means that there are very clear means of ensuring that the data protection rules, the GDPR, will be interpreted and applied consistently throughout the EU. This is what was very important for the legislators, for the Commission already coming up with the proposal, that by moving from the directive to the regulation, directly applicable act, we ensure that this directly applicable act is also applied and interpreted in a uniform form throughout the EU. Of course, there is always the possibility to go via the courts, via preliminary proceedings, going to the Court of Justice in Luxembourg, which will give the ultimate interpretation of the regulation. But this switching in of procedures and elements which force out cooperation and which force out a common decision by the authorities who need to apply the regulation in specific cases, fosters this harmonized application of the regulation already up front. Just one additional point. All this cooperation, maturity, the possibility to impose fines, it all rests, and the regulation also underlines this, on truly independent DPAs. And the regulation really embodies the development which was really done by the Court of Justice on the basis of the directive, spelling out what does it mean for data protection authorities to be independent and to which extent this independence needs to be ensured. The regulation also provides that it's all very nice, you have the tools of mutual assistance, joint operations, and the powers, but imposes the obligations on the member states to equip data protection authorities with sufficient financial and structural and resources in order to be able to cooperate efficiently together, in order to be able also to apply efficiently and effectively the regulation on the national level. Indeed, one of the very important points in this tissue of tools which the regulation provides for in order to ensure consistent interpretation of one law, so one law interpretation, are the guidelines. Guidelines is a soft law instrument. Guidelines adopted by the European body, and the European Data Protection Board will be one, mean one thing, that they restrict, that this body adopting such a guidelines restricts its discretion while applying certain notion. Guidelines are, however, not binding on controllers or on the courts. So the final interpretation of all the terms which need interpretation will be given at the end of the day by the courts, by the national courts, and ultimately the Court of Justice. I think it would be this on my side, I think we will be discussing this element of fines and what Article 83 provides for, which elements need to be taken into account, and how does it work a little bit later. Thank you very much.
Thank you so much. And I think if I can then give the floor to Romain, because I think he wants to expand a bit on the role of the EDPB, and I see some nice slides that can maybe make this a little bit more visual to us.
Yeah, thank you. Thank you for the invitation as well. As you say, it was a challenging time I think it's a challenging time for the controllers and all the privacy professionals, but it's also a challenging time for the DPAs, because implementing the GDPR is not only a task for the controllers, but also for the DPAs. And we are working, as Gwendal just said it, a lot to be prepared for day 1, 25th of May. It's a challenge because, first of all, we will have new tasks given, as Karolina explained, to the DPAs, not only by the GDPR, but also by the ePrivacy regulation, depending on the outcome of the ePrivacy regulation, of course, because it's not even clear what would be the cooperation between the DPAs in terms of ePrivacy, the police directive, and also maybe other powers like the coordinated supervision that will be all together to be handled together by the DPA. So it's a new task and a new challenge for us as well. You will see that the new powers and new missions have been given to the DPAs, like the sanctioning power that, for example, was not existing in the Belgian DPA until now. So this law of the 3rd of December in Belgium was voted to provide the Belgian DPA with these new powers of sanctioning. So you will see that DPAs will be very new and very young in this application of a new exercise of fining, sanctioning, and issuing corrective measure in the DPA. So even for the DPAs themselves, it's going to be a new exercise. And of course, as we just explained, we have new cooperation instrument like the mutual assistance and the joint cooperation. The main goal, the main instrument for cooperation is, as you know, called the one-stop shop, which is a really nice name for a not so simple procedure. And I have a nice slide. There's only 2 slides that I have to show that I would like to share with you, and I will have to prove my IT skills, I guess. Is it working? Yeah. So you will see how things were simplified in the GDPR. It's very simple to understand if you've seen. This is the one-stop shop in one sketch on the slide. It seems to be complex. It's not that simple, but when you just go through it and you read it after 20 times, I think you can understand a bit of what is the one-stop shop about. The basic principle of the one-stop shop is, of course, that when the authorities are not agreeing between each other, they will have to go to the EDPB to apply what we call the consistency mechanism. This one-stop shop has not been applied yet. We're working a lot to try to implement it on the procedural level. As Gwendal explained, we are, as DPA, the Working Party 29, working a lot to adopt guidelines, cooperation mechanism, to talk a lot with each other, to know how this is going to work in practice. There are still some gray zones that you might have identified already. The one-stop shop will not apply in 3 cases. For example, when, according to Article 55, I think, you have a national law providing a legal obligation to provide to process data. For example, a data retention obligation. You will not be subject to the one-stop shop. There is also this urgency procedure, which is an exception to the one-stop shop, and another case, which is the local case. And that's, for me, something very obscure to understand when the local case exception, which is when a local authority receiving a complaint should or should not be the one handling the complaints, or should we apply the one-stop shop mechanism. This is still something that has to be, I think, further detailed by the Working Party 29, I hope. So it's still there's still some work to do to try to clarify this so-called simplification of the cooperation procedure that you can see on the slide. So that's one big challenge for DPAs as well. EDPB will be a new EU organ. It's I think it's really, the first organ and body, EU body of this kind, adopting binding decisions that can be challenged before the Court of Justice. Other decisions might be taken by agencies of the EU or for the European Patent Office, which is not EU body. So I really think the EDPB is a new structure. It will be provided with legal personality. We'll be able to adopt binding decision, which makes a big difference with the Article 29, because binding decision means professionalization of the decision-making process, of course. Potential challenge before the Court of Justice, which is also another challenge. And therefore, the big question will be, will the EDPB become an Article 29 2.0 or 1.5? They will depend on a lot of factors, from, for example, the number of cases, cross-border cases that the EDPB will have to handle, the powers and the resources given to the DPAs, of course, and the cooperation tools they are put into place. In this respect, as you know, the EDPS will now be providing the Secretariat to this new structure, which means that a lot have to be prepared as well. In cooperation with the DPAs, we put into place a nice IT instrument to exchange information between DPAs in a timely manner and very efficient manner, which is already a system used for exchange of information between member states. This is a very practical tool, but it has to be put into place, and I'm sure Gwendal will agree, to meet the very strict deadline that just Gwendal just raised. We, for example, in the consistency mechanism of the decision taken by the EDPB, have 1 month to adopt a decision when the DPAs do not agree on the national level. So 1 month is not that much when you just consider the language issue, the right of defense issue, the translation issue, the meeting issue. How can you organize a meeting between 28 authorities for them to agree on a draft decision within 1 month? So it's a lot of practical challenges as well for the EDPB. And last point that I would try to address, so this is the one-stop shop cooperation mechanism. You will see it's, of course it's a funny slide, it's not that complex, but I just wanted to show that it might appear some complex in some cases. Is the EDPB the last step of the consistency mechanism? As you were just told, in case of failure of the one-stop shop, the EDPB will have the power to adopt binding decision on a specific case, but it is not the last step. As Karolina explained, the Court of Justice will have the last say on the interpretation of the GDPR. And you will see that when the EDPB will adopt a decision, it can still be challenged by the, before the Court of Justice, by the controller, for example, because the controller will, of course, be concerned by the decision of the EDPB. This decision of the EDPB will be applicable to the DPA. The DPA will have to adopt at the national level a new decision. This new decision can also be challenged before the national court by the controller or the plaintiff. So we see the EDPB is not the end of the process, but we can also have some next steps, I would say, after the decision of the EDPB, which is also part of the consistent application of GDPR, of course. We already know that the Court of Justice was quite active in the last year to interpret the data protection law. So I guess we will have to wait whether the Court of Justice will approve, and I'm just looking at Gwendal, the guidelines that we adopted. I hope this is not a work that will be disregarded by the court, but of course, DPAs are, with the guidelines, are striving to try to interpret the text of the GDPR, and we will have to wait whether the EDPB will have a final say or the Court of Justice to know what is the final position on some interpretation of the provision of the GDPR. So that would be it for me, presenting the EDPB, the one-stop shop, and the possible complexity of the after EDPB decision. I hope it was quite clear.
Yes, thank you so much, Romain, and clearly very complex, but I think it's interesting to hear that this is challenging for DPAs, and that there are tight deadlines that will be difficult to meet, etc. Karolina, you wanted to make a quick
just
point?
One, because the Commission wants to wants to make sure that this is not made more complex than it is. Just to clarify, that for whom these decisions of European Data Protection Board are challengeable acts. And here we send you back to Article 263. If for somebody who is not the addressee of the decision, and the addressees will be only concerned authorities, the conditions of this article will need to be fulfilled. So I think Romain was underlining it very much, and we want also to underline it that precisely this Article 263 of the treaty, with the conditions of direct and individual effect of such a decision of the board to whoever would like to contest it would need to be met, and it will depend very much on the content of each individual binding decision. To which extent does it restrict the margin of maneuver of the National Data Protection Authority? But I think the case law here from the court is very extensive, very vast, when this condition of a direct individual concern is met, and recital 143 addresses this issue a little bit. So just to complement what Romain was saying, not to give the impression that each and every binding decision of the board will be an attackable act for the controller, that the controller will have a standing for it. Yeah, I think because you hinted in this way, but I just wanted to make sure that everybody understands it.
Thank you for confirming. You just thank you, Karolina. If it was not clear, I didn't want to leave this room with this impression because
then
only this specific situation. Yeah. No, otherwise, it's gonna be hell after 25th of May, of course. Yeah.
Exactly.
Well, thank you all. I think. Still very complex, though, but thank you for clarifying. I think it would be good to hear what the business perspective is. Karolina, how are businesses approaching the new regime?
Sure, thanks Laura. And if it's complex for regulators, think about companies who have to try to understand all of this. So I'm struggling here with this. Mastercard, as you all know, is a global payments and technology company. And so our role is to authorize, to clear, and to settle card transactions on behalf of our customers, which are the banks. So basically what we do is we connect your bank, which has issued your Mastercard card, and we connect your bank with the bank of the merchants, which accepts the Mastercard card. And then we facilitate the exchange of information and the exchange of funds between those two banks. Mastercard takes privacy very seriously. Because if you think about it, our whole brand and reputation is built on the safe and responsible use of your transaction data. So how do we prepare for the GDPR? Well, first of all, by the time the GDPR was adopted, we had already the full support and buy-in from senior management and CEO. And that is really key. And so today, actually, the GDPR implementation is included in our CEO's objectives for 2018, which really demonstrate that it's a key objective of the company. The first thing we've done is we have appointed a project manager, because I'm sure you all agree, the GDPR is a monster regulation, and so it requires a monster project to implement it. And project management is really an art per se, right? So having somebody fully dedicated to managing the project, making sure that all the work streams are on track for compliance by May, this is really key. What we've also done is we've started by engaging with the organization and launching that major privacy awareness campaign, so that every single employee in the organization, whether they are based in Brussels, in London, even in New York or Singapore, they all have a basic understanding of the GDPR. Because to achieve effective protection, privacy cannot remain the exclusive responsibility of the privacy team. It has to be a shared responsibility. Every single employee in the organization handling personal data has to understand what it can be what can be done and what cannot be done. And actually, we're lucky to have a communications expert in our team, and so she helps us translating the privacy jargon into clear and easily understandable messages. And she even comes up with very innovative and fun ideas as to how to communicate about privacy. And so we've tried it all. Games, quizzes, songs, dances, you name it. And now the whole organization is just looking forward to our GDPR updates. Now, to address all those requirements, what we have done is we've tried to implement enterprise level and technological solutions as much as possible. So let me give you an example. We are building that data inventory, an automated data inventory that allows us to know in real time what data we have and on what platform it's stored. And for each data, we have the permissions and the restrictions that are attached to that data. And that has key benefits. First of all, it enables us to better comply with the GDPR. We document our activities, and if we respond to data access requests, well, we have an easy way to respond to that because we know exactly what data we have and where the data is stored. But it also creates opportunities for the business. Now they know what data is available and how that data can be used right away without having to consult with us. We are also developing access portals as interface between us and consumers so that it's easy for consumers to communicate with us and to exercise their rights. And all those tech solutions are being implemented on a global basis, right? And they have key benefits because, first of all, it reduces mistakes due to human errors. It allows real-time synchronization of data, of consents, of requests. And then it frees up some time for our team. Priceless. And as you know, I mean, as you probably all know, and as you probably all experience, the legal work stream is also extremely heavy. So to give just an example, updating all the contracts with vendors, customers, and partners is a mammoth task. At Mastercard, we have actually tens of thousands of customers, which are the banks, and so for each of them, we offer multiple solutions, multiple products, where we collect different types of data for different purposes. Sometimes we are controllers, sometimes we are processors, sometimes we are both. So just the paperwork and the logistics of those contract updates is just a challenge. And then when our customers start to negotiate the terms, or even worse, sometimes they think it's like the best opportunity to audit Mastercard. Well, that's a real nightmare. And then what we have also done is we have set up a steering committee that is composed of our general counsel and the head of IT and the head of each business line. And that committee meets once a month to track progress and make sure that each executive is actually accountable for their own area. Because again, our team, the privacy team, cannot actually be made responsible for the whole implementation of the GDPR. Everybody has to bear its part, its burden. And then last but not least, we are organizing workshops with our customers across Europe to explain our approach and to offer assistance. And that's particularly relevant for the small merchants, SMEs, who really struggle to understand the GDPR and to implement it. And so the idea is really for the whole payment ecosystem to be ready and to be compliant by May this year. And actually the clock is ticking, right? I think today is only 4 months left, so no time to waste. What about you, Sachiko?
I echo Karoline's approach, and I also am quite amazed that although you and I being in two completely different field of business, I actually am the European Privacy Officer and also Data Protection Officer for many, many years for my company Acxiom, which is a leading service provider in the marketing and MarTech area. And you know what I thought it was really, really interesting? You said something about you have appointed project manager. I think this is a very, very good point, which is not reflected in the GDPR itself. But don't forget, your privacy department, your legal department, there you have people who are really, really good in data protection law, right? But who says there are at the same time fantastic project managers? They usually aren't. I was really amazed. You know what, GDPR, to ensure that there will come no enforcement towards our direction, you know, what we have done was just like Karolina at Mastercard, we have different project groups, and I'm really, really impressed how these professional project managers can coordinate the things. For instance, they have like an Excel-like thing, like a spreadsheet, where they really track, you know, to update the policy. Okay, to update the policy, this section, that section, you should do it by week 24, and then this one should be completed by week 32, and so on. and then you keep up this spreadsheet, you drive this, and then assign tasks to people who are in the working group.
And you chase them.
And to chase them. And you know what? Chasing them is like a very, very difficult task, and you really need somebody like that. Was it Romain? Did you say that, or was it Gwendal? I forgot. But then one of you said, you know, 1 month is such a short period of time. No, it was Romain, you, right? 1 month is such a short period of time. And one of the things that you said was, what about arranging a meeting with all these people? Well, it is exactly the same in the businesses that are doing the implementation work. So I get really to appreciate this new skill, project management, which is going to be essential in ensuring a high level of data protection within an organization. This is something actually new, because until now, whenever I was talking about, the importance of the DPO, I meant, is that you really need to have a DPO who's a very good communicator. Because listen, GDPR is making your company change its characteristic. It is making your company become a data protecting culture. So that's why communication is really important. And I knew that from before, but then now with this implementation projects left, right, and center, I really come to think, to appreciate that project management is another skill that we need for a successful implementation of the GDPR. What I also, another point that I actually also want to highlight is, before going to enforcement, right? The first thing that you actually need to tackle is how to deal with the complaints, how to deal not only effectively, but with sympathetic communication that is going to help the data subjects who are raising the concern about the way the company is using the data in a way so that you can also emit this information. We are really concerned about you, and we really want to make sure that that we do no bad. I mean, at the end of the day, no company in the world is out there to trick you or do bad things. This is not what they want. The other way around is actually the story, because not only due to the GDPR, but already for like many years. If you want to have a great business opportunity, if you really want to make money, right? You need to have trust. You need to gain that trust from your customers and your prospects. You only have that when you have credible track record and a credible system that is implemented within the organization, which backs that claim up. So anyways, I think the first thing that is really important is the moment that there is a complaint, that you deal with this complaint seriously in the most effective manner, and they're communicating this person sincerely. Having staff that are dedicated into explaining data protection jargons in a more everyday people vocabulary is really key. And then now from that complaint, I actually go one step further. So then this person will then escalate the complaint, if that he or she is not happy with the answer that they're getting, to the DPAs. And then here you go. A very important role of DPO would pop up. I can't cite the articles like Karolina can do. I'm so envious. She's really good. I mean, sorry, take a look at her GDPR. I mean, it's like in pieces. You can see that she has really digested her book. But DPOs are really key into actually helping this communication element between the DPA and the organization. So the moment DPA says, okay, there's a there seems to be a problem, let me contact that company, oh, this person is the DPO, then I think it is very important that this communication goes very smoothly and very intensively. what I think the GDPR has really brought to us is this requirement for the DPO to provide the necessary context and the necessary detailed knowledge of how things were. Let us take a step back. GDPR is an evolution. You guys are all right. It is an evolution. We have been dealing with this already for many, many years. But it formalizes certain tasks that we have been carrying out until today. And it also allows a smoother and more systematic way to evaluate each and every situation. Because remember, every data processing is unique. Every data processing is contextually bound, and you cannot expect the DPA to know every nitty-gritty detail about how the ad tech company is working, or how that particular data has been used and processed. What were the, you can of course provide the data protection impact assessment, but then only you, with your thorough, detailed contextual explanation, I believe, that it would make the DPA truly understand what exactly was the context, what exactly was the evaluation of the DPO of the processing. And in this way, I think one can come to a more rounded, more contextually holistic evaluation also by the DPA, and obviously if it will be contested, EDPB and then a local court, whatever, that I think interaction is going to very, very help. So my conclusion from this is that me being a DPO myself, and also having a really good dialogue with my local DPA, I have a feeling that GDPR is going to start a new era in terms of the relationship between the DPA and the DPO. And I think I echo many DPO's opinion as well. We are here to help, because at the end of the day, we are all in the business of making sure that our data is appropriately protected as GDPR has envisioned it.
I'll just jump in to react to a couple of points that were made by Sachiko. First of all, complaints are not something that is new, and we don't simply receive complaints and enforce something based on a complaint without checking what is in the complaint. In France, so just so you have the figures in mind, we receive 8,000 complaints per year, and on the specific issue of delisting, which has been discussed over and over again at the European level. I think it's for more than 400 complaints that we receive following a refusal by the search engine to delist the person. And each time, of course, we check what is in the complaint. In some cases, we provide an answer. In some cases, the person has not been following the process when they filed the complaint with the DPA. In some cases, this will trigger an inspection to know more, and so on and so forth. So the responses that are given by DPAs to complaints are informed, and in some cases also there's also discussions with other DPAs at the European level. Another thing, I mean, on DPIA and the fact that of course, the company is supposed to know what it's implementing and what the safeguards are. The job of the DPIA is not only done by the DPO. It's about putting people around together, putting people around the table together, because most of the time what is sent to the DPO is incomplete information, and before you can actually do the DPIA, you will need to talk to the CISO, you will need to talk to the person who is developing the product, you will need to talk to a lot of people in the organization. So the DPO is not on his own in the company, and on the DPA side, we do have the technical expertise to understand what is being done by companies. I mean, for instance, at the CNIL, I'm the director of the CNIL of Technology and Innovation. We have a team of good experts on technology issues that are very trained in that topic, and they examine very complex technical issues. And this is why we have developed this team, to be able to understand what companies are doing, and give appropriate advice which makes sense both legally and technically. So this is just to complement what was being said by Sachiko. And of course, data protection is becoming more and more technological, and I think what I was saying for the CNIL is also valid for many DPAs. We see it in the technology topics that are being discussed at the Article 29 Working Party. It's taking more and more space, and it's, I think, essential today.
Well, thank you, Gwendal. I'd like to just take maybe 5 minutes for the panelists to maybe ask each other some questions before I give the floor to the audience. Do you have any questions that you have for the other panelists?
Yes, I do. Yes, get ready. So actually, I'm not really concerned, despite the complexity of the whole system. I'm not too concerned about the one-stop shop and the consistency mechanism. I trust DPAs and the board. I think actually you are doing a terrific job to get ready. What I'm concerned about is more about the possible increase of litigation, and I just wonder whether judges and courts are well prepared. Have they even heard about the GDPR? And if so, how do we make sure that they fully understand the requirements, and how do we make sure that they adopt a consistent interpretation across Europe? Because we've spoken about the Court of Justice of Luxembourg, but I mean, we cannot expect the Court of Justice to rule on every single case, right? And so I think, in my view, that it's one of the big challenges, and I wanted to hear your views.
Maybe I will start. Romain will probably want to complement. First of all, it's not an area which is different than from all the other areas of the EU law, where precisely the same thing happens. That national judges are the EU judges, and they have the task of interpreting the EU law. And if the system works well, then indeed, slowly, but it will reach the Court of Justice, and more and more case law coming from the Court of Justice will be then developed. And as Romain already mentioned before, there is already quite some case law which is very well known, and the judges do know it. I also know, by the way, that data protection authorities are reaching out and providing for different courses also concerning the data protection authorities, also to legal professionals. And so I think that I do trust very much in this way the EU law works, and I do not see why it's supposed to fail here. It's not a more technical or more complex or more whatever area than all the other areas in which the national courts apply the EU law and look at the decisionary practice or from the Commission or from other authorities throughout the EU. I think here about telecom, I think here about, and the whole telecom package there, I think here about competition law, where there is, where there are quite some aspects which need to be taken into account by the national judge somewhere, into account while deciding. So I'm very, actually reassured that it will work with all the time that it will take, but it's just a normal way of dealing, of developing the EU law and consistent practice also by the courts. Romain, you would like to add something?
Not really. I think
you agree. Perfect. Oh, this is very nice. Thank you.
I'm reassured, I guess.
Any other questions, Sachiko? I see you're looking at me, but
no. I mean, At the same time, I also very much understand in the data protection field, this is something really new, that we have this consistency mechanism and all the decisions would be uniform. So as much as it is for the challenge for the DPAs and the organizations, the controllers and the processor, I think also I'm very encouraged to hear about the fact that DPAs are reaching out and educating the judges, the courts, because it is going to be indeed a catastrophe if the court cases
I wouldn't say that the DPAs are educating the judges. They're providing for the possibilities for specializing courses, something like this. Let's be careful.
I appreciate the nuance.
But I think, there are different elements which bring it all together. First of all, data protection authorities talk to each other. It's more forced out. And I know, Gwendal, you're right. It was already before, but nevertheless, we had different Google Street View cases, where the decisions were going in very different directions. And in Germany, actually, we have it among the 17 data protection authorities that there's still, even within member states, there are such a different decisions or interpretations. So on the one hand, we have data protection authorities who talk to each other before the decision is taken. In all the cross-border cases, we have one interpretation. I mean, if such a decision is being attacked in front of the national court, this is already quite some background there, which was discussed and so on, so that the national judge will be provided with all this information and with the exchange of views and what national data protection authorities took into account while reaching this decision and this interpretation of the regulation. So I think that we have this push from the cooperation and already consistent interpretation on the side of the decisions which will be attacked and checked by the courts. Of course, there is this way of data subject going directly to the courts and not via data protection authorities, and then the courts deciding directly. But then again, this here, I would fall back of what I said before. This is nothing particular from the point of view of the way EU law works, and it works actually very effectively, still respecting the independence of the judges, the procedural autonomy of the member states, and all of this, which is also very important for the member states, and maintaining what was very important to the member states while discussing and while negotiating this regulation, the closeness between the data subject and its own national judge, where somebody can make all the claims in the language, in its own language, in front of the national judge.
Karolina, may I ask you then in that light, right, the closeness and also the ability to communicate. If you think about the bulk of the controllers and processors, actually, it is not going to be for them to actually say they may not be fixed to which DPAs. In other words, in choosing a one-stop shop or to choose a representative in the EU, it may not necessarily have to be bound based on the relationship that they have with one particular country, but maybe they just decide to arbitrarily choose a country. Now, in that sense, and this is a big question, I suppose it is not to be found in the GDPR, but the international language is English.
Yeah.
And my question would be, if processors and controllers that are not based in the EU, when they are going to choose in which country they are going to put their representative, where they are going to appoint the DPO, is there an effort in the perhaps this is more within the Working Party Article 29 story, is there an effort to actually ensure that every DPA will be able to correspond and carry out all the analyses, etc., in the English language?
Well,
I think it's a very, very important question, and I think it's a fair question. Because you're just mentioning this company would not be established in the EU, right? And then you asking whether you should appoint this DPO in the country when the lead DPA would be. But I have something to tell you. There will be no lead DPA because there is no establishment in the EU, so the one-stop shop will not be applicable, and this DPO would have to talk with all the national authorities of the EU. But I understand what you say, and it's something that I hear a lot of time, and I looking at Karolina to confirm what I say. That's something that was quite clear from the Commission. This one-stop shop is an incentive for the companies established in the EU. If you're not established in the EU, you will not be entitled to the one-stop shop.
Let me clarify.
Exactly, so this choice, because I was not sure I understood it very much in the beginning.
Maybe I should say so. Hypothetically, then maybe a company that is not established in the in Europe would now strategically think, okay, I am then now going to establish so that I do have the possibility to have a choice, to have one.
Of course,
in
but
that case,
this company will take this decision where to have the main establishment in the sense of the regulation, and this is a defined term. And it will be not because I don't know whether Romain had the same, but I think that we had the same lamps, like blinking here, like, the lead, it's not like aleatory and I'm just choosing and going something. It goes, it's an assessment, and I think in the guidelines addressed it very clearly. This is a very clear assessment about what is the main establishment in the sense of the regulation, unless the decisions on means and purposes of the processing operations are taken somewhere else. So this is what needs to be established, and it's actually a factual assessment, and the company will need to make this decision where to do it and how to do it, how to restructure itself so that it can take the advantage of the one-stop shop. And then data protection or data protection rules and data protection authority with which you want to deal is probably one of the aspects which you take into account while you're establishing in the EU, because probably tax laws and other aspects are being taken into account, are very much weighted up. Where does it pay off to have the main establishment? And here, indeed, the establishment, whether an establishment and a main establishment for the purpose of the one-stop shop is the same. It's another issue we can discuss, probably. Romain, you want to add something?
Just one anecdote, because in a conference at the IUPP, I think it was 3 months ago, we had this question from a company where the main establishment was Switzerland. And they were like, oh, how am I going to be entitled to the one-stop shop? And so I'm sorry, it seems that first sight, depending on the future of the agreement that we might have with Switzerland, you're not entitled to one-stop shop. And the answer was like, I'm not going to be establishing myself in the EU just for privacy reason. Oh, and it's interesting. What are the reasons why you're established in Switzerland for the first place? It would be interesting to know. Of course, tax reasons. And it was interesting to know that this company was willing to establish in Switzerland for tax reason, but not in the EU for privacy reason.
Thank you. I think
let's be clear. I mean, Switzerland has an adequacy decision with the EU. It's not an EEA country, so it's not even the question of the agreement here. It's actually a third country for the purposes of data protection rules. Indeed, in view of Schengen, it needs to transpose police directive, but the GDPR, it's a different story.
So thank you all, and thanks for that anecdote as well. I think the audience also has some questions, and I saw a gentleman at the left there. Maybe if you can state your name and organization before you ask your question.
Talks with everyone, so I find this strange. One question for Romain. The secretariat will be built up for the board. Will the secretariat have analytical input for the process? That's one specific question. So are they actually going into doing the evaluation and not just providing papers and copying and stuff? One thing, for the colleague from the French authority, proactively checking on business and going into business areas and checking how the GDPR is being taken up there is, I think, key. You can't wait for complaints. You probably don't have the staff for really putting out a big agenda there. So that question would also go to the lady from the Commission. And how far will you go in actually enforcing or looking after the member states and the resourcing of the DPAs? I think that's also a key question of this whole approach of the GDPR, which very much focuses on enforcement. I come from a generation of data protection officers who really at a certain point said there is no way to enforce. We have to kind of find a way to together voluntarily come up with a competition between the companies in throwing out trust products on that basis. So I find it interesting, this whole GDPR approach of enforcing, but will there be the resources? Will it be really strictly taken up by the Commission?
Since my answer is the shortest, then I'll just... Just to reassure you, Commissioner Jourova, in the beginning of last year already addressed a letter to the member states in this respect, drawing attention to Article 52.4, that it's an obligation for the member states to provide data protection authorities with human, technical, and financial resources, premises, infrastructure, so as to enable them, indeed, to do mutual assistance, joint operations, and to cooperate with each other. So this is one. And second, of course, the Commission is the guardian of the treaties. We retain all the powers to enforce to ensure that the EU law is abided to, and if it's necessary, we will take the decision. So I think that the fact that the letter was sent is already sent addressed to all the member states, and this issue will be raised now in the JHA Council in Sofia next week. So I think next week even again is something already very telling.
For the question on the CNIL, in France we have various missions as a DPA. We inform data subjects, we give advice to data controllers, we do enforcement through inspections and sanctions, and we try to anticipate what is going to be a challenge for us as a DPA in the next future years. We already do quite a lot of inspections. We do 400 to 500 inspections per year, which are triggered either through the work program, which is adopted and published each year, or the complaints that we receive, or when something pops up in the press and requires an inspection by the CNIL to check if things are done in the proper way. And finally, we work a lot, you know, what I said before, to try to define the rules as precisely as possible in different sectors. And we have different legal instruments for that, to say, for instance, a recommendation in a specific sector, saying how data protection legislation has to be applied, and this gives more clarity, if you want, to so it's not always a binding decision, and the courts can go against this to a certain extent, but they take this as a means that to interpret the law. So this is how it's being used currently by the courts, and it's useful for us to assess what is sent to the CNIL, and it's useful for data controllers because they know practically how they need to implement the rules and the data protection law.
Trying to answer shortly to your question. Yes, the answer is yes, it's provided in a GDPR that the Secretariat should provide analytical work. We will hire other lawyers and privacy experts, I mean even 5 this year at the Secretariat. We are just trying to get the budget, of course, because resources is not about only the DPAs, but also the Secretariat of the EDPB, because we might be subject to a lot of work, of course. So analytical work is provided by the GDPR. It's not only people serving the coffee and booking the meeting rooms, hopefully. But of course this responsibility might be shared with the national expert, of course, but this is provided in the GDPR. This analytical part of the Secretariat is in Article 75, I think, already.
So I see some more hands. Well, maybe the lady at the right, in the back. Okay.
Thank you. Carola over the West, I'm a privacy lawyer. I was triggered to attend this panel by the text in the program that the panel will also analyze regulators' priorities and agenda and discuss the trends in the enforcement actions. But, well, I did listen quite well, but I didn't hear any. So could you please elaborate on that?
Maybe Gwendal, that is a question for you on priorities for DPAs.
Priorities, as I said, we have, in terms of inspections, there's a work program which is adopted and published every year by the CNIL. And also depending on the complaints that we receive, this is how we do add-ons to the work program, or different topics that come up in the press.
And then maybe the other lady, yes. Thank you.
Yes, I happen to work for the Swiss government, and I can confirm that there is concern from Swiss companies about the one-stop shop mechanism. But one question that they ask us, and I don't have a clear answer to that, is how are you going to enforce decision and sanctions if foreign companies don't have an establishment in the EU, and possibly they don't even have physical assets? And yeah, I don't know if you have an answer to that question.
I was hoping that you would grab the mic before me, but
it's the way we do it in competition law, exactly the same way. And it depends, but here it's the Commission. And how is it going to be done by the data protection authorities will depend also very much on the procedural settings in the national member states.
I would agree, yeah, because of course it would be a problem. It might be a problem. I really think that I would raise an issue, but I don't have the answer of this responsibility of this representative, because, you know, if you're not established in the EU, you have to have this representative in the EU. I must say that it's not clear for me whether you can find a representative or not. I think the GDPR is not quite clear about it. Maybe the national implementing laws, which were not supposed to be necessary for a regulation, but will precise this thing. And that might be a criteria to choose your representative, to appoint your representative in a country where you don't have finding powers to the representative. I will be killed to have said this, I guess. But that's something which is not clear, I think. But anyway, you can still, of course, sanction and take corrective measures against the establishment outside the EU. Same thing as in competition cases. There are also, if for example, this controller, let's say very concretely, is offering services in the EU through internet, why not blocking the service on the internet? Because suspending processing of information, since one of the power of the DPA, you can also, for example, just block the service if it's not complying with EU law in general, which is not, as Karolina would say, a new thing as well. It's not, GDPR is not a new thing to enforce. We already enforced EU law before, so as you say, it's not revolution.
Well, and just maybe because Romain was very careful about this representative fines or not. I think Article 27.4 says mandated, so all the issues concerning the enforcement of the regulation, all issues related to processing for the purposes of ensuring compliance with the regulation. Okay. This is what the regulation says. Compliance fines, one of the corrective measures, something seems to be one of these elements. I'm just saying seems to.
Thanks for the answer, because it was I was provocative on purpose, but
something that probably will be discussed.
Yes.
But the regulation is based, and it's the reason the establishment of the representative, effective enforcement of the regulation. This is where we are coming from.
Any other questions? Gentleman here, do you have a microphone or?
I'll speak up. About anonymity, one of the questions I often get from customers is whether the DPAs will have any specific language requirements. Will you, for multinationals, accept, for example, will you accept English documentation, or does it need to be in any of the national languages, depending on which DPA takes the lead in an investigation?
Actually, that was my question, which I was leading up to. So thanks for asking that.
Well, for you as a secretariat, probably much more to answer, but you want to give it, because from our point of view, I just can tell you that it's actually a right to be able to speak the language of your establishment. Yeah, if you're in the Netherlands, it will be the Dutch. If in the one-stop shop cases you have an agreement with data protection authority and you want to renounce on this right, because for the ease so that, and maybe also to facilitate the work of the data protection authority, which the secretariat is now working it out, in which languages, in the cases, the cross-border cases, the cooperation will work, but maybe it will then facilitate also the work of the data protection authority lead and the concerned, then well, we do not see, we the Commission, we do not see a big problem with it. But I'm going back to Romain because this is the Secretariat. We are stopping to be the Secretariat.
I'm happy you don't see a problem, because we saw a problem, of course, but Because goes two things. As you mentioned it, there was this right to address a complaint to your national authority, and it is also subject to the national law regulating the use of languages. In Belgium, it's quite complex as well. So you're supposed to file a complaint in German, Dutch, or French to the Commission Belge de la Vie Privée. The other thing is, because you were mentioning the one-stop shop, it's not supposed to be of interest for the controllers and the data subject. They are not intervening in the one-stop shop. At the national level, they are, but at the one-stop shop per se, they are not taking part in the dialogue between the DPAs. This dialogue, of course, and we're just still discussing about it, should be able to take place in English, which would be the working language of the DPAs together. And there is a third layer, which is the EDPB itself, where the working language is and should be, I guess, still English, as it was for Article 29, which would not be a problem. Just to give some hints, there is a regulation on the use of languages in the EU, Regulation 1/48, which is only applicable to the institution of the EU. The EDPB is not an institution in the EU body, and the subject is not filing any complaint directly to the EDPB, but to the national DPA. And the clients of the EDPB are the DPAs. So this language issue has to be solved between, but maybe I didn't understand your question, Paul, I'm sorry. But I didn't understand your question.
From the companies.
Yes.
Evidence from the data controllers in any investigation. Are there language requirements for that? Because that is for data controllers to concern. Do we have to maintain all our records, for example, in any of the countries where we operate in the EU?
To be provided to whom? To the national DPA?
To the national DPA in case of an investigation.
The national.
Or should that be in English? Or could that be in English?
So my answer is, it's depending on the national law of the DPA. If the national law of the DPA provides that you have to communicate with this DPA in French, all your evidence should be translated in French. For example, in Belgium, because I was working as a lawyer and also in the Privacy Commission, the law just allows you to waive your right to work in French, or you can also have an agreement with the Privacy Commission to submit your annexes in English. It's all depending on the national law. That is the principle of autonomy of procedural law in the member state. So it's up to the member state to decide this language. But I understand that it's an issue because you want to make sure that your evidence will be readable by the whole EDPB. That is a problem that we are handling now. I don't have a solution. We can talk about it, Paul, later at the coffee if you want. But I understand your view. But at the national level, it's a national law providing the use of languages that should be used. One-stop shop is not involved. It is not. They will deal with this problem of languages at the one-stop shop level. The DPAs will find translation issue. We already have IT mechanism for translation, budget for translation that is already foreseen a little bit. And the DPB is somehow another problem that we will have to tackle, but we will deal with it. It's not the first time that the EU body is dealing with languages. Competition cases in Commission are the same kind. But I understand you, it's a fair point. At national level, it's national law. And I know for a multinational company, it's not a super nice answer to hear, I would say.
Well, thank you, Romain. I think maybe one last quick question and then we all go for lunch. Okay.
Thank you. Good morning. I'm Yasmina Sbahi from Morocco. I'm working in a bank in Morocco, and I'd like to know, in fact, in my bank, we do not have a physical presence in Europe, but we have clients in Europe. So I'd like to know if GDPR is applicable for us, and if yes, what do we have to do to be compliant with the GDPR? Thank you.
Well, Article 3.2. If you are offering goods or services to the EU citizens, residents, you are subject to the GDPR. Full GDPR.
And I would add, I'm very curious that you're offering client banking services in the EU without having an establishment. It's a regulated activity. So I'm like, I don't know. I'm not.
You are probably compliant
Yeah,
with other regulations in
I'm
the
sure
EU
you're
when
really
you are
compliant.
offering. When you, it's not, but it's really it's not that your page is accessible to the European citizens. Yeah, it's not enough. You need to target our citizens. The conditions of Article 3.2 are offering goods and services. And here I would send you to recital 22 in particular, which puts a little bit more flesh on it. But I don't know whether it means that, for example, it's not enough if you have your page in English, then it doesn't mean that you are targeting our citizens. But if you have this page also and you provide for services and you charge it in euro, then yes. Yeah, the currency, some other elements which we will need to take into account. And in addition, Article 29 still started to work on the guidelines on the interpretation of Article 3, which will provide you with more information on how they intend to enforce the article. But I think Article 3.2 with the recitals, and I sent you, I think 22, 23, 23 is a very good language, currency, ordering goods and services in this language, mentioning of customers whose users are in the union and so on. So there are certain elements which need to be taken into account while assessing whether the conditions of Article 3.2 are met.
Well, thank you, Karolina, and I think, Karolina, I think it's useful also to know that these guidelines are coming up. I think that brings us to the end of this panel. So if you will all join me in giving our panelists applause. Thank you.